Chapter 45. Creditors' Suits. Analysis. Section 871. In general, the jurisdiction of equity to entertain suits in aid of creditors undoubtedly had its origin in the narrowness of the common law remedies by writs of execution. These writs, issued by courts of common law, besides being otherwise limited in their operation, were, of course, confined to those estates and interests recognized by the law, and did not extend to estates and interests equitable in their nature. Creditors' suits were therefore permitted to be brought in those instances where the relief by execution at common law was ineffectual, as for a discovery of assets, to reach equitable and other interests not subject to levy and sale at law, and to set aside fraudulent conveyances and obstructions. Statutes in England and in certain American states have greatly extended the scope of writs of execution, thereby providing for adequate legal relief in cases where formerly resort to equity was necessary, and even extending the relief to instances where, perhaps, a creditor's bill would not lie. In other states, statutes have increased the efficiency of creditors' suits by dealing with the subject directly. Section 872. Adequacy of legal remedy. In general, supplementary proceedings. It is a necessary result from the whole theory of the creditors' suits that jurisdiction in equity will not be entertained where there is a remedy at law, but such remedy, in order to oust and prevent jurisdiction in equity, must be in all respects as satisfactory as the relief furnished by a court of equity. The question has frequently arisen whether certain statutory remedies have not provided an adequate remedy for the creditor, especially, whether the proceedings supplemental or supplementary to execution existing in many of the states have not rendered the suit in equity unnecessary and obsolete. The question should be solved in accordance with the well-established principle that where new power is conferred upon the law courts by statutory legislation, unless the statute contains negative words or other language expressly taking away the pre-existing equitable jurisdiction, or unless the whole scope of the statute, by its reasonable construction and its operation, shows a clear legislative intent to abolish that jurisdiction, the former jurisdiction of equity to grant its relief under the circumstances continues unabridged. Creditors' suits which have for their object the setting aside of fraudulent conveyances have not been supplanted by supplemental proceedings. It seems to have been the intention of the framers of that statute, creating supplemental proceedings, to provide a summary process for the discovery, and application to the judgment, of property subject to execution, concealed and withheld by the debtor, or others in collusion with him, without pretending, when it came to attest under oath, to assert any substantial ground therefor. But where the property alleged to belong to the judgment debtor is claimed by others, either by way of absolute title or pledge or mortgage, or debts claimed to be owing to the judgment debtor are disputed by his alleged debtor, such claims of ownership, lien, or denial of indebtedness cannot be adjudicated and determined summarily. Further, a creditor's bill may still be resorted to for the purpose of reaching equitable interests, and it has been maintained that it will lie, in a suitable case, for the purpose of discovering and reaching concealed assets. It is obvious that dicta to the effect that creditors' bills can only be pursued in exceptional cases are careless and wholly misleading. Section 873. In case of fraudulent conveyance, other remedies are inadequate. Legal remedies for reaching property conveyed in fraud of creditors are rarely adequate. Though the conveyance may be utterly void, and the property liable to seizure and sale on execution, the execution purchaser receives a title clouded by the apparent title of the fraudulent grantee. The legal remedy is slow and expensive compared with the equitable, and much more hazardous. In the legal procedure the method is circuitous. An action must be pushed to judgment and execution, a seizure or levy made, and then another action instituted to settle the title of the property so attached or seized. Equity settles all questions with all parties in a single suit. The remedies under the attachment and garnishment laws are not as adequate and efficient to reach property conveyed or transferred in fraud of creditors as is the remedy in equity. Section 874. But complainant must show the necessity of setting aside the fraudulent conveyance. It is usually held, however, that the judgment creditor has no ground for interfering with the fraudulent conveyance, If at the time when the creditor's suit is brought the debtor has other property subject to execution sufficient to discharge the debt. If his debt can be satisfied out of property upon which his judgment is a lien, it is only inviting useless litigation for him to question conveyances made by the debtor, which, however they may have been intended, do not operate as a fraud upon him. And where the judgment debtor turns over to his creditor property ample, if converted into money, to pay the debt, a court of equity clearly will not entertain a bill to reach other property. The statute, existing in several states, which authorizes a simple contract creditor to subject property fraudulently conveyed, or attempted to be fraudulently conveyed, by the debtor, changes the rule, and authorizes the creditor to proceed without regard to the existence of other legal assets. The fact that a surety is solvent will not cause equity to refuse relief against a fraudulent conveyance by the principal debtor. Where judgment has been obtained against two or more debtors jointly, one of whom has made a fraudulent conveyance, the better opinion appears to be that the complainant, seeking to remove the fraudulent obstruction, is not required to show that the other judgment debtors have no property upon which a levy can be made, or that the legal remedies against them have been exhausted. And though a judgment debtor has property in another state subject to execution, his creditors are not required to go out of the state of their residence in search of that property, before proceeding in the state of his and their residence to subject to their judgments property transferred in fraud of his creditors. Section 875. Discovery of assets. The complainant may demand and obtain a complete discovery of the defendant's assets and a disclosure of the names of his debtors. Even if no relief can be afforded by the court in which suit is brought, the complainant is entitled to discovery for the purpose of enabling him to reach the defendant's property through the medium of the proper legal tribunal. Section 876. What property may be reached? Intangible property. The principle that a creditor's bill may reach any property of the judgment debtor which, by reason of its nature only, and not by reason of any positive rule X, emptying it from a liability for debt, cannot be taken on execution at law, extends to such intangible property as a patent or copyright. Such property is capable of assignment, and may be reached in a creditor's bill by an order directing its assignment to a receiver appointed for the purpose of applying it to the payment of the judgment. Section 877. Choses in action. It is probably the majority rule that, in the absence of statutory authorization, a creditor's bill cannot reach the choses in action of the judgment debtor, unless the case presents some independent ground of equity jurisdiction, such as fraud, trust, or the like. It is claimed that the purpose of creditors' bills is not to give a new species of execution which the law does not afford, but that they merely present instances of the exercise of jurisdiction based on other well-recognized grounds. The conceded failure of justice consequent upon the denial of the jurisdiction results from no defect in the ancient common law which it is the business of equity to supply, but from the act of the legislature in abolishing the common law remedy of execution against the person. It is to be observed that this reasoning implicitly denies the jurisdiction of equity to reach intangible property as well as choses in action. Numerous cases, however, support the jurisdiction of equity to reach the debtor's choses in action, when the execution cannot be otherwise satisfied, independently of fraud or other ground of jurisdiction, basing the jurisdiction on the general power of equity to furnish a remedy when the strict rules of legal practice fail. The defect in the jurisdiction of equity, if it exists, has been very generally met by statutes giving the judgment creditor who has exhausted his remedy by execution the right to proceed against the choses in action of his debtor, in order to obtain satisfaction of the judgment. It seems that a chose in action that may be reached in equity must be one that is in its nature assignable. Thus, a verdict in the debtor's favor for damages in inaction for a tort to the person, on which judgment has not been entered, cannot be reached by the creditor. On the other hand, a cause of action for the conversion of, or injury to, the debtor's property may be subjected to the creditor's claim. It is held that alimony awarded to a wife cannot be applied by creditor's bill to the payment of a debt contracted before the decree of divorce. Alimony is not strictly a debt due to the wife, but rather a general duty of support, made specific and measured by the court. It is property in one sense, but not in the broad general sense of the term. It is a specific fund provided for a specific purpose, with restraint and limitation written all over its face by the very law and decree which brought it into existence. Section 878. Contingent interests. A contingent interest may be subjected to the payment of debts by a creditor's bill. Where a will provides, however, that an heir is to take nothing until his sister becomes of age, a sale of his interest will not be decreed if it will cause an inequitable sacrifice of his property. Section 879. Equitable interests. In general, any equitable interest of an execution debtor may be reached by a creditor's bill and subjected to the payment of the debt. As examples of the equitable interests and estates which can be reached may be mentioned: property held for the debtor on an express trust, a trust resulting to the debtor from payment by him of the purchase price of property and procuring the title to be taken in the name of another, improvements placed by a debtor husband on his wife's land, an equitable interest in land for purchase money unpaid, an equitable interest by virtue of an executory contract for its purchase, an equity of redemption. To the rule that all equitable estates and interests of the debtor may be subjected in equity to the creditor's claims, an important exception exists in those jurisdictions which recognize the validity of so-called spendthrift trusts. In those states it is competent for testators and grantors, by will or deed, to construct and establish trusts, both of real and personal property, and of the rents, issues, profits, and produce of the same, by appropriate limitations and powers to trustees, which shall secure the application of such bounty to the personal and family uses during the life of the beneficiary, so that it shall not be subject to alienation, either by voluntary act on his part, or in invitum, by his creditors. The grantor, however, cannot, by creating a trust for his own benefit, place the proceeds of the trust beyond the reach of his creditors. By the statutory policy of many states, following the lead of the New York Revised Statutes, the income of all trusts created for certain designated objects, such as the support and education of the Statute Trust, is put beyond the reach of the Statute's creditors, except so far as it exceeds the amount necessary for accomplishing such objects. A creditor's bill lies to reach the surplus income only. By the statutes of other states, all trusts created by or proceeding from a person other than the debtor himself are exempt from the operations of a creditor's bill. Section 880. Fraudulent transfers of personalty may be set aside. A creditor's bill to remove a fraudulent obstruction to execution may be directed against a fraudulent transfer of personal property as well as a fraudulent conveyance of real property. It is not often used for this purpose, however, the general practice being to levy on personal property and determine the ownership by action of replevin. Section 881. Property which cannot be reached by the suit. Motives of public policy clearly prohibit a suit to reach the salary of a state official. In a majority of cases it is held that garnishment does not lie against a municipal corporation. A municipal corporation cannot be turned into an instrument or agency for the collection of private debts. It has been held that for the same reason a creditor's bill cannot be maintained against a municipal corporation to reach money due its employees or contractors. Other cases establish the more reasonable rule that if the court can ascertain that no inconvenience can result to the public in a given case, the suit may be maintained. The defendant in such a suit may be compelled to assign his demand against the municipality to a receiver to be collected and applied to the satisfaction of the plaintiff's demand. Property devoted to a public use by a private individual or corporation is frequently exempt from execution, and likewise from a creditor's bill. Thus, it is held that land dedicated for a public cemetery cannot be reached, although the owner of the legal title to a portion of the lots receives a portion of the revenues derived from the sale thereof for burial purposes. On the other hand, where taxpayers had obtained a decree declaring a contract void, it was held that they were entitled to a decree in aid of execution subjecting the property of an electric light plant. There are various statutory exemptions, such as homesteads, which will prevent a creditor from reaching property even by a creditor's bill. A homestead exemption, however, cannot avail against a creditor's bill unless it exists when the bill is filed. Under the federal statutes, Indians are entitled to many exemptions, but a lease of lands in the Indian country may be reached by creditor's bill. Money in custodia legis, in the hands of a clerk of court in his official capacity, cannot be made the subject of a creditor's bill. Section 882. Necessity for judgment at law. Statutes changing the rule. In the absence of statute, a simple contract creditor cannot, in general, maintain a creditor's bill. Before resorting to equity, he must reduce his claim to judgment at law. In regard to bills to set aside fraudulent conveyances, it is frequently said that the complainant must have either a judgment at law or some lien upon the property sought to be reached. Most of the cases laying down this rule are mere dicta upon the point, although we shall see that there is considerable real authority for the statement. The reasons given for requiring a judgment are two. 1. That equity should not interfere to aid a legal right before the legal remedy is tried. 2. That a simple contract creditor may never obtain a judgment, and, if he does not, he cannot be injured by any disposition of the property. In a few jurisdictions the equitable rule has been changed by statute, so that suits to set aside fraudulent conveyances may be maintained by simple contract creditors. The federal courts refuse to follow these statutes, however, upon the ground that the money demand is a mere legal claim, upon which the defendant is entitled to the benefits of a jury trial. Section 883. What judgment is sufficient? A judgment of a court of record, based upon a claim either in contract or in tort, is ordinarily sufficient. A fraudulent conveyance may be set aside, therefore, although when made the complainant had only an unliquidated claim for damages in tort. In some states, judgments of inferior tribunals, such as justices' courts, are not sufficient, unless steps are taken to make them a lien on real estate. Ordinarily, a judgment of a court of a sister state will not sustain a bill, and the same principle applies to judgments of federal courts when used as a basis for creditors' bills in state courts. Upon this latter question, however, there is a conflict of authority, some courts allowing the judgment of a federal court for a district comprised within the state to serve as a foundation. The federal courts will sustain a creditor's bill upon a judgment of a state court. A judgment which is reversed on appeal is, of course, not sufficient, but the mere fact that an appeal is pending does not prevent the creditor from maintaining his suit in equity. As to the effect of a judgment becoming dormant while the bill is pending, there is a conflict of authority. In general, the judgment cannot be attacked in the equitable proceedings, but if it is void, it is not sufficient to sustain the bill, and relief will be denied. Section 884. When judgment may be dispensed with. To the rule requiring a judgment as a prerequisite to a creditor's bill, a few exceptions are allowed in some jurisdictions. Thus, it is sometimes held that a creditor need not obtain judgment before resorting to equity to reach assets of a deceased debtor. A few states allow a resident general creditor to maintain a bill to reach property of a non-resident debtor within the state. Likewise, exceptions have been made when the debtor has absconded and cannot be found within the state, and when the debtor is insolvent and the claim is undisputed. It has been held that a trustee in bankruptcy may maintain a bill to set aside a fraudulent conveyance without first obtaining judgment at law. A general creditor, whose claim is recognized, has been allowed to attack a general assignment for the benefit of creditors, and where there has been such an assignment, and the assignee refuses to sue to set aside a fraudulent conveyance, some courts allow a general creditor to bring the suit, upon the theory that he is a beneficiary seeking to enforce a trust. Section 885. Is an attachment lien sufficient to support a creditor's bill? It is established by perhaps the weight of authority that an attachment which creates a lien upon real property may be the foundation of a creditor's bill to set aside a fraudulent conveyance. This lien is entitled to protection by courts of equity, so that there may be no fraudulent obstructions to the due execution of the process. Accordingly, it has been held that one who has obtained a judgment in another state may obtain relief upon an attachment issued within the jurisdiction, and that a resident creditor may resort to equity immediately upon obtaining an attachment against the property of a non-resident. Where, for any reason, the attachment creates no lien, it would seem that the bill should not be maintainable if the authorities are not unanimous. However, in supporting bills resting upon attachments, many courts of the highest character refuse to recognize such liens as the basis for equitable interference. and much reason seems to favor their view. Section 886. Steps beyond judgment in suits to reach assets not subject to execution. What steps, if any, must a judgment creditor take before filing a creditor's bill? In determining this question, many courts have distinguished between two classes of cases. The first, a creditor's suit, strictly so called, is where the creditor seeks to satisfy his judgment out of the equitable assets of the debtor which cannot be reached on execution. Generally in that class of cases the action cannot be brought until the creditor has exhausted his remedy at law by the issue of an execution, and its return unsatisfied. This is required because equity will not aid the creditor to collect his debt until the legal assets are exhausted, for until this is done he may have an adequate remedy at law. A return of execution unsatisfied is accepted by the courts as proof of insolvency, that is, insolvency so far as assets which can be reached at law are concerned. In some jurisdictions it is held that a return of execution is not the only evidence of insolvency that will be received, that insolvency is a fact which may be proved by any competent evidence. There would seem to be strong reasons in favor of this view, although it has not been generally adopted. Section 887. Same in suits to remove fraudulent obstructions. The second class of cases is where property legally liable to execution has been fraudulently conveyed or encumbered by the debtor, and the creditor brings the action to set aside the conveyance or encumbrance as an obstruction to the enforcement of his lien. For, though the property might be sold on execution notwithstanding the fraudulent conveyance, the creditor will not be required to sell a doubtful or obstructed title. In the latter class of cases the prevailing doctrine is that it is not necessary to allege that an execution has been returned unsatisfied, or that the debtor has no other property out of which the judgment can be satisfied, for that is not the ground upon which the Court of Equity assumes to grant relief in such cases, but upon the theory that the fraudulent conveyance is an obstruction which prevents the creditor's lien from being efficiently enforced upon the property. As to the creditor, the conveyance is void, and he has a right to have himself placed in the same position as if it had not been made. The fact that other property has been retained by the debtor may be evidence that the conveyance is not fraudulent, but, if the grantee's title be tainted with fraud, he has no right to say that all other means to satisfy the debt shall be exhausted before he shall be disturbed. In most jurisdictions, the docketing of a judgment creates a lien upon the debtor's realty within the county. It is generally held that the judgment must be a lien upon the property in order to warrant relief, and accordingly a judgment without execution is not sufficient to authorize a court to set aside a fraudulent transfer of personal property. On the other hand, it is held in some states, in regard to realty, that it is not necessary that the judgment should be a lien. Some states require a return of execution nulla bona in all cases, including cases of fraudulent conveyances. Section 888. What is a sufficient return of execution? An execution, in order to form part of the basis for a creditor's bill, should be directed to and returned from either the county where the judgment was obtained or where the debtor resides. A return of an execution issued to an other county is not sufficient. A return made by the sheriff before the return day named in the writ, at the order of the plaintiff's attorney, is sufficient if it appears that the sheriff has made demand and has been unable to find any property. Otherwise, such a return is insufficient. It has been held that a return showing merely that there is no personal property is not sufficient, and for this reason, a return of a constable who has no authority to levy on realty, will not support a creditor's bill. Section 889. Limitations and laches. Under the reformed system of procedure in many of the states, the statute of limitations is made to apply to equitable actions, and accordingly, creditors' suits come within its provisions. Cases where the question generally arises are those in which the creditor seeks to set aside a fraudulent conveyance. The general form of statute as to fraud is that the action is barred after a certain named time from the discovery of the fraud. Even in a case where the fraud is discovered, however, it is generally held that time does not begin to run until the right to maintain a creditor's bill accrues. As to when the right does accrue there is not unanimity of opinion, but most courts hold that, At least, a judgment must be obtained at law. This question has been fully discussed in the preceding paragraphs. In some states it is held that the recording of the deed is sufficient notice of the fraud. As stated in a recent case, the statute runs from the time the mistake, by ordinary diligence, ought to have been discovered. In some jurisdictions it is held that a creditor, having notice of a fraud, must reduce his claim to judgment within a reasonable time and then bring the creditor's bill. The statute begins to run at the expiration of this reasonable time. Of course, in states where it is not necessary to reduce a claim to judgment before maintaining the creditor's bill, the statute begins to run from the time of the discovery. The circumstances which prevent the running of the statute are the same as those which apply generally. The mere fact that a debtor has fought an action at law so persistently that the creditor has not filed a bill, is not sufficient excuse. If an action is brought by one creditor in time, it is immaterial, so far as the statute of limitations is concerned, at what time the intervening creditors become parties, for, as each creditor appears and proves his claim, he has a right to be considered a party complainant from the beginning. Of course a creditor whose claim is barred by the statute of limitations cannot maintain a bill to set aside a fraudulent conveyance. It is generally held that the extension of the statute of limitations to equitable remedies does not abolish the equitable doctrine of laches. Professor Pomeroy, in his Code Remedies, says, not a provision is to be found in the code of any state adopting the new system which requires, suggests, or even intimates an abrogation of equitable primary rights, or equitable remedies and remedial rights. The change provided for is not in primary rights, nor in remedies, but in the methods, means, and instruments by which these primary rights are to be maintained and these remedies secured. Mere delay does not always, in and of itself, constitute laches. As stated in a recent case, the effect of the statute of limitations is to eliminate the requirement of excusatory facts in a bill purely equitable of mere delay in time when the suit is commenced within a period fixed by the statute. The result is that the right to maintain a creditor's bill may be barred by laches although the statutory time has not run. Thus, it has been held that where a party has slept upon his rights for a period of 9 years, with knowledge of the fraudulent character of the deed sought to be invalidated, and has allowed the opposite party to spend his money, or waits until the lands have greatly increased in value, either from such expenditure or otherwise, a court of equity might properly refuse to interfere, although the statute of limitations has not run. From the foregoing it would seem that the rule is that lapse of time coupled with circumstances which would render it inequitable to grant relief by a creditor's bill, will be a bar, whether the statutory period has elapsed or not. Section 890. Who may bring suit? Primarily, a creditor's suit must be brought by a creditor who has fulfilled the requirements described in the preceding sections. An assignee of such a creditor is also allowed to sue, and his right to set aside a fraudulent conveyance is unaffected by the principle that causes of action for fraud are not assignable. In some jurisdictions it is held that after a valid assignment for the benefit of creditors, such assignee is the only party who can sue, although if he refuses, a bill may be filed by any creditor. A trustee in bankruptcy may, likewise, bring the suit. A surety who pays a judgment has a right to maintain a bill without obtaining judgment himself, for he succeeds to the rights of the judgment creditor. Before payment, however, he is not entitled to sue. Section 891. Parties defendant. The courts are not agreed as to who are necessary parties to the bill. The jurisdictions which require suit to be brought on behalf of all the creditors allow all creditors to be made parties, but it is doubtful if all are necessary parties in any jurisdiction. It would seem that the debtor should be made a party, for he is vitally interested in the outcome, and his rights are directly affected. The party who has possession of the property sought to be reached must be joined. It is a general, though not universal, proposition, that all who have interests which will be affected by the decree in the property sought to be reached must be made parties. In suits to set aside fraudulent conveyances, all whose interests will be prejudiced by a decree setting aside the conveyance must be made parties. As in the case of other creditors' bills, the debtor, who is either the fraudulent grantor or the party who secures the conveyance, should, it is generally held, be made a party. In addition, the fraudulent grantee must be joined, for his interests are usually the most important at stake. Where there are several fraudulent conveyances, the several grantees may be joined as defendants in one action. The object and purpose of the suit is single, the satisfaction of the demands of the creditors from the property of the debtor, and all that can be said is, that different persons have, or claim to have, separate interests in distinct or independent questions connected with, or springing out of that common purpose. Where the grantor or grantee is dead, his executors, administrators, or heirs are necessary parties, according to the law of the jurisdiction as to what party is the representative of a deceased person in suits relating to his property. A party in possession of the property, although he be the sheriff in case of a collusive attachment, must be joined. The trustees of all deeds of trust on property sought to be sold, and all the creditors named therein, are necessary parties. In some jurisdictions it is held that the cestui of a trust deed is not a necessary party, for the defense of the trustee is the defense of the cestui. The court may in its discretion, however, allow the cestui to become a party. Where a fraudulent grantee assumes a mortgage on property, the mortgagee must be joined. In all the cases the test seems to be whether one has an interest in the property which cannot be taken from him without giving him a chance to be heard. It is not necessary to join those whose interests will not be affected by the decree. Section 892. Joinder of parties. Plaintiff, one creditor suing in behalf of others. Several and separate judgment creditors may unite in an action to remove a fraudulent conveyance made by their common debtor, since they have a common interest in the relief sought, and in those states where simple contract creditors are authorized by statute to sue, they may join as plaintiffs with judgment creditors. If the plaintiff professes to sue both for himself and for such other creditors as may choose to come in and share in the expenses of the suit, it is obvious that he gains no priority over such creditors in the distribution of the proceeds of the suit. In such a case the question may arise as to the power of the creditor who files the bill to control the proceedings. If other creditors have come in, or if an interlocutory judgment has been rendered establishing the rights of the parties, the original complainant cannot of his own motion dismiss the bill. Where other creditors have not come in, however, it has been held that he may dismiss the bill. In Alabama, a creditor is allowed to maintain a bill although other bills by other creditors on behalf of all are pending. A creditor's bill filed to reach property fraudulently conveyed by a debtor on behalf of all other creditors who may see proper to come in and make themselves parties, will not preclude other creditors from proceeding in like manner by original bill, until there has been a decree upon the merits granting relief. Section 893. Creditor suing for himself obtains priority. It is the general rule that in a judgment creditor's suit a single creditor may file a bill on his own behalf, that he is entitled to retain the priority thereby gained over other creditors, and cannot be forced to divide with them. Three methods of proceeding are open to the creditor whose execution at law is returned unsatisfied. Was the conclusion arrived at by Chancellor Walworth, in a leading case, that he might file a bill to reach the equitable estate of the defendants, either in his own name and for his own benefit, or might join with others standing in the same situation in a joint suit for their joint benefit, in proportion to the amount due to each, or that lie might file a bill in the usual way, in behalf of himself and all others standing in the same situation, as judgment creditors whose executions had been returned unsatisfied, and who might choose to come in under the decree, and contribute to the expenses of the suit. I can see no reasonable objection to either mode of proceeding. The latter, at the first blush, may appear the most equitable, but the two first are much more likely to ensure a vigorous prosecution of the suit, and, on further examination, it may seem unjust that the creditor who has sustained all the risk and expense of bringing his suit to a successful termination, should in the end be obliged to divide the avails thereof with those who have slept upon their rights, or who have intentionally kept back that they might profit by his exertions, when there could no longer be any risk in becoming parties to the suit. Since priority among different creditors' bills is gained by the creditor who first files his bill and serves process, it is said to be immaterial in what order the judgments which are the foundations of the different suits were recovered. The priority is not defeated by the death of the debtor before judgment in the creditor's suit. A few courts, however, making an application of the maxim, equality is equity, hold that all creditors should be let in, upon reasonable and appropriate applications, even where the bill is filed on behalf of one creditor alone, and allowed to participate in the proceeds of property fraudulently conveyed. Section 894. Except in certain suits, where a trust or quasi-trust exists for all creditors, it is not to be understood, however, that it is possible, in every variety of creditors' suits, for the plaintiff to prosecute the suit for his exclusive benefit. The subject is well elucidated in a recent opinion delivered in the Court of Chancery of New Jersey, by Pitney v.C., that class of creditors' bills in which the suit can properly be said to be necessarily brought for the benefit of other creditors besides the complainant are those which seek to reach, establish, and administer assets in the hands of a trustee, who holds them either voluntarily, or by force of circumstances, involuntarily, for the benefit of all the creditors. They may be classed as follows. First, suits to administer the estate of a decedent, held by an executor or administrator, and apply the same to the payment of his debts. Second, where a living debtor voluntarily assigns property to a trustee for the benefit of his creditors, and a creditor seeks to have that trust administered. Third, where there is an assignment by operation of law for the equal benefit of creditors, such as occurred in all instances of attachments against foreign or absconding debtors under our statute, until the recent change in that respect. Fourth, cases where a creditor of a corporation seeks to reach unpaid subscriptions of stock. Fifth, a creditor's bill under our Chancery Act, sections 88 to 94, in which equitable assets are reached by a receiver, and are all subject to the debts of the defendant, but not distributed pari passu, and the complainant is first paid. In all these cases the property reached becomes assets in the hands of the court, to be distributed among the creditors, either equally, or with certain priorities. To the classes thus enumerated should be added other exceptional cases where the creditor is allowed to pursue his remedy in equity without having first reduced his claim to judgment. The Court of Chancery does not give any specific lien to a creditor at large, against his debtor, further than he has acquired at law, for, as he did not trust his debtor on the faith of such lien, it would be unjust to give him a preference over other creditors, and thus defeat a pro-rata distribution, which equity favors, unless prevented by the rules of law. Although all creditors may have the right to share in the proceeds of a suit, it is not essential that the plaintiff should allege in his complaint that the proceedings are for the benefit of all the creditors. Section 895. When the lien of the creditor's bill accrues as to property not liable to execution, the plaintiff obtains no lien by the issuing or return of execution. It is the filing of the bill, and service of process after the return of execution, which gives the plaintiff a specific lien. The filing of a creditor's bill and the service of process creates a lien in the nature of an equitable levy upon the effects of a judgment debtor, including real property conveyed in fraud of creditors. But in order thus to create a lis pendens, operating as constructive notice, as to any real estate, the bill must be so definite in the description, that anybody reading it can learn thereby what property is intended to be made the subject of litigation. Moreover, the fraudulent grantee must be made a party to the bill in order to charge with constructive notice a purchaser from him of the legal title pendent light. In respect to chattels, subject to be taken on execution, the rule in some states seems to be that unless the action is brought in aid of an execution, the mere commencement of the action creates no lien as against other creditors, and, if any lien whatever exists, it is so incomplete and imperfect that it is subject to be overreached by a subsequent levy in favor of other creditors, made before the appointment of a receiver. It is the appointment of the receiver in such a case which makes the lien effective and gives the plaintiff priority. Of course, the lien acquired by a creditor's bill cannot displace a legal lien acquired before the bill is brought.